Hello everyone, welcome to StudyIQ English. My name is Praveen Mishra, and as usual, we are going to discuss another burning topic of the day. So, as you can see on your screens, on one side it's the Tamil Nadu Chief Minister M.K. Stalin, and other side it's the Governor of Tamil Nadu, that is R.N. Ravi. Since R.N. Ravi has taken charge as the Governor of the state of Tamil Nadu, since the very beginning itself, we have seen a good ample amount of tussle or strife has taken place between the governor and the government itself. Majority of the times, yes, sometimes either side, that is the governor or sometimes the government, they both were right. But this time, the news is what it is telling, that the government of Tamil Nadu has taken up a victory against R.N. Ravi's action. And this victory is something that is justified by the Honorable Supreme Court of India. What's the whole news all about? So here we go. So as you can see the news, the Supreme Court on Tuesday, that is just yesterday, ruled that Tamil Nadu Governor's R.N. Ravi's action for withholding the assent to exactly 10 bills that are passed by the state legislature and forwarding them to the president was absolutely illegal. Okay, once they were reenacted, right? And then it was sent to the president. It was absolutely illegal for the governor to do that, and it was also termed as non est factum, that is, declaring an agreement as illegal. Okay, so it was erroneous as well, it was violating the principles of the constitution. So, what is the whole story? Tamil Nadu governor, that is R.N. Ravi, he provided and actually he used his suspensive veto and sent back some of the bills, exactly 10 bills for the reconsideration. And when the reconsideration was done and the bill was sent back to the governor, this time he withheld the assent for a long time and didn't provide any specific answer. And yes, to the new thing, he transferred the veto, he transferred the assent to the president, right? Asking the president to come into the action and provide the assent in case you are willing so. So what's the whole news again? So R.N. Ravi's action of withholding his assent, okay, to the 10 bills passed by the state legislature and forwarding them to the president after they were reenacted by the state legislature was absolutely illegal. Once you have used your suspensive veto, that is, once you have sent the bill back for the reconsideration, and then the bill has came back to you, and now you are transferring the veto for the assent of the president. This is illegal. This is against the principles or the provisions of the constitution. Simply not allowed. That's it. Okay, guys. So this is what the whole news is. And now, talking about the further of the statements that Supreme Court has given, and before we enter into the rest of the slides, the first thing that we need to discuss, with this judgment, that is R.N. Ravi's withholding of the assent and then transferring the assent for the president, assent to the president, okay, this is a landmark event as well. This is a landmark judgment, a landmark case as well in our Indian polity. And now, this has provided some new extra elements, new as well as extra elements to our constitution, as well as, specifically speaking, to the federal structure, the quasi-federal, obviously, the quasi-federal structure of our country. That is under Article 200. Okay, now there will be many more things that will be read by all of us, right? So here we go. The other factors. The Supreme Court's order. So what Supreme Court order? That since the bills remained pending with the governor for an unduly long period of time, very, very long period of time, and Ravi did not act in a bona fide manner. Ravi, that is, R.N. Ravi, governor, did not act in a bona fide manner by reserving the bills for the president's consideration. The bills are deemed to have been assented to by the governor on the date when they were represented to him after being considered by the legislature, right? So let's understand the whole genesis here. Okay, how are the things done? When it comes to the governor's assent, okay, when it comes to the governor's assent, okay, to bills, The governor has got a veto. Veto as in we call it as suspensive veto. The governor as well as the president. Okay, that is what is known as suspensive veto. Though yes, also got the pocket veto, that is withholding the asset. And yes, after that there is something that is termed as transferable veto. Okay. So now in this case, the suspensive, pocket and transferable, all the three vetoes were kept in question. Now talking about the first one, that is the suspensive veto concept. How do we define suspensive veto? So suspensive veto is, let's say for example, there is a bill, okay, this is the XYZ bill whatsoever, okay. This bill of any state legislature will become an act only when the governor has provided the assent. Same ways, when it comes to the union or the central level, bills passed by the union parliament will become an act only after the president has given the assent, right? So XYZ bill is there, passed by a state legislature, any state legislature, okay, whatsoever. Now, this bill will be sent to the governor. Now, when governor is reading the bill, let's say for example, governor is reading this XYZ bill, there are some provisions there, okay, in which governor found that, let's say for example, there are 1, 2, 3 and 4 provisions. Let's say just for instance, for example, the governor found that provision number 4, okay, this provision number 4 is not correct or might be, disturbing to the political structure or maybe the social structure or the economic structure whatsoever in any way around the other, okay. Let's say for example, this 4th provision or 2nd or 3rd or whatsoever the provisions, they are disturbing in nature. So in that case, the governor has the authority here to send the bill back, okay, send the bill back to the state legislature with the letter that, okay, in my opinion, these are the provisions which are disturbing in nature or maybe not correct, okay, against the constitution, against the law, etc., whatsoever the reasons he or she may cite, okay, and that's it, okay, the governor's role is done. Now it is the state legislature again. Now the bill is once again into the court of state legislature. The state legislature, here in this case, when the bill is returned by the governor for the sake of reconsideration, let's say now this is the bill, once again, it is now into the court of state legislature. Okay. Now the governor has said that, in my opinion, point number 4, okay, this point number 4 was not correct. So is it now obligation onto the state legislature to act on the advice rendered by the governor or on the recommendation given by the governor? No, absolutely not. Let's say they even won't open the bill if the state legislature, if doesn't even opens up the bill and just sends it back as it is, as it came. Then at second instance, when the bill is now again sent to the governor, now governor is obligated to give the assent to the bill. Okay, so governor's recommendation, okay, or whatsoever suggestions when it comes to the reconsideration of the bill, it is not under obligation to the state government, to the state legislature. The state legislature is not obligated to follow the recommendations or to follow the suggestions. Okay, they may not. It's absolutely voluntary to the state legislature. Okay, so once the bill is sent back to the governor again, with or without reconsideration whatsoever, with consideration or without consideration, doesn't make any difference. This time, in the second instance, the governor is bound to provide the assent, and this is known as suspensive veto. Okay, so this particular provision, it is what is known as suspensive veto. right? Now, what has happened to 10 bills passed by the Tamil Nadu legislature, state legislature? Governor sent the bill back for reconsideration. And once the reconsideration was done, the bill was sent by the legislature to the governor again. And this time, what governor did? Governor used his transferable veto, right? Which veto? Transferable veto, and sent the bill for the assent of the president. Now, for this, Supreme Court has stated this is not constitutionally permitted. It is you only who will have to give the assent. It's not the Honorable President of India. It's the governor only. So this is what Supreme Court has ordered since the bills remained pending with the governor for an unduly long period of time, very long period of time, and Ravi did not act in a bona fide manner. Okay. By reserving the bill for the president's consideration, the bills are deemed to have been assented to by the governor on the date when they were presented to him after being reconsidered by the legislature. So, now what Supreme Court said, using Article 142, that once the bills, they were represented to the governor, now the bills are set to be passed, that is given up the assent. Okay, so finally, what the verdict is? The verdict, which is authored by Justice Pardiwala, said, having regard to the unduly long period of time for which these bills were kept pending by the governor, before the ultimate declaration of withholding of assent, and in view of the scant respect shown by the governor to the decision of the SC, and for the SC as in Supreme Court, for the other extraneous considerations that appear to be writ large in discharge of his functions, we are left with no choice but to exercise our inherent powers under Article 142 of the Indian Constitution to declare these 10 bills as duly passed and have been assented. Right? So what's the whole thing? Whole justice or whole verdict actually? So we have Justice Pardiwala. He gave the crystal clear judgment that since the bills were kept for unduly long time with the governor R.N. Ravi and they were not given any sort of assent, and in fact some unconstitutional measures were also taken up, and for which now we are left with no other powers, no other systems, but only using Article 142. What is this Article 142 now? Using Article 142, Supreme Court can declare that an order or a decree passed by the judiciary must be, yes, the word is, must be applied throughout the territory, or in the respected cases, events or territories wherever necessary. Right? So this is what Article 142 is. And using Article 142, Supreme Court has imposed its judgment, imposed its orders, and said that once the bill was resubmitted or resent to the governor R.N. Ravi, and when he didn't provided the assent and once again took a hold over it, that is used the pocket veto and withhold the bills, and this time took an extra advantage of sending the bills for the presidential assent. Now that was constitutionally not permitted, and hence using Article 142, Justice Pardiwala, that is Supreme Court, clearly stated once the second time the bills was represented to the governor, it is now set to be deemed passed and had the assent. Right? So this is what judicial overreach could be in the opinion of some of you people, but no, this is not judicial overreach. This is absolutely judicial review. This is absolutely judicial activism as well, where Supreme Court has compelled a public office bearer, a public office holder, that is to perform your duty through all the constitutional and moral means. That is following simply the aspects of constitutional morality, the elements of constitutional morality. Right? So this is what the whole logic is with regard to the verdict. And here comes the next things, the next wonderful things. The bench held that there is no concept of absolute veto or pocket veto under the constitutional scheme. Absolute veto as in just declaring the bills as null and void. That is no, I am rejecting the bills. You can't pass it. So absolute veto is neither given to the president with regard to the union parliament, neither the governor with regard to the state legislatures. Yes, president has been gifted the absolute veto with regard to the state legislative assembly bills in case the governor has transferred the bill for the assent of the president. But yes, it is not yet been given to the president for the union parliament as well as to the governors for the state legislature. Right? So the bench held that there is no scope of absolute veto as well as there is no scope of pocket veto as well under the constitutional scheme. You can withhold, yes, but withhold it for a specific amount of time, and for which yet it was not defined by the constitution, but yesterday, that is on 8th of April 2025, Supreme Court defined the time limit as well. Okay, so as what we can see, there are some conditions here. Okay, so as per Article 200 of the Constitution, the governor is expected to take one of the three courses of action on bills, that is, grant assent to the bills, second, withhold assent to the bills, or third, transfer the bills for the presidential assent. Right? So these are the three things as we have already discussed. The bench ruled, this is what the statement came from. The top court, that is the Supreme Court, held that the bill can be reserved for the president only at the first instance, that is, when the bill is now passed by the state parliament, that is the state legislative assembly, and now sent to the governor for the assent. In that first instance only, the governor has the authority to use the transferable veto and send the bill for the presidential assent, using the discretion as well as the advice of the state cabinet. But let's say president on the first instance has used the suspensive veto and has transferred the bill once again back to the state parliament, that is the state legislative assembly, for some reconsiderations with some recommendations and so on. Then in that case, when the bill is once again presented to the governor, now governor will have to sign herself or himself only. At the second instance, the governor cannot transfer the bill for the presidential assent. That is not constitutionally correct. And this is what Governor R.N. Ravi has done this time, and this is what Supreme Court has stated. Wrong. You cannot. You can send the bill for the presidential assent, no doubt in that, but at the first instance only. That is for the first time when the bill has come to you, not on the second stage. Right? So here we go. As a general rule, okay, what Supreme Court has stated, as a general rule, it is not open for the governor to reserve. It is not open for the governor to reserve a bill for the president after the bills have been represented by the government after being passed again by the assembly. Okay, the only exception is, there is one exception. Okay, just one. The only exception is when the bill presented in the second round is different from the first version. Okay, so let's understand the whole scenario. Okay, it might be confusing, I understand, no problem. Let's eliminate the confusion. So this is the bill. Okay, once again XYZ bill. Okay, bill passed by the state legislature, right? This is state legislature bill. At first instance is sent to the governor. Okay, the same bill. So governor here has got the options. What are the options? Firstly, to have the transfer, that is transfer to president. That in my opinion, this is a bill that should be considered by president only. Okay. Second, could withhold. That is using the pocket veto, that okay, I'm considering it, I will let you know in some time. Okay, what is the exact sometime value? Not defined. Okay, and third, okay, that is providing the assent. Okay, that's fine, I'm giving the assent. Okay, so these are what the veto powers under Article 200. Okay, which article? Under Article 200. They are given to the governors of the states. Okay, now let's say it is the first time when state legislature has sent the bill to the governor. Then in this first instance only, okay, governor can use the transfer veto, the transferable veto. Okay. Now, the second case, the second scenario. Let's say state legislature, okay, has sent the bill to the governor, and the governor has returned the bill to the state legislature once again. Okay, so now this time governor has sent the bill, okay, and has used his this suspensive veto. Okay, that is, in my opinion, there are few provisions in the bill, few exhibits in the bill that I think they are not correct. Okay, reconsider it. Okay, fine. So state legislature may reconsider or may reconsider not, may or may not reconsider whatsoever. Okay, both of the options could be there, right? Even if they do or they don't do. In the second instance, now the bill is sent to the governor second time. Okay, after the reconsideration. Okay, now at that time, precedent transferable vote veto is not allowed to the governor. Okay, when the bill has been sent after the reconsideration, that is second time. Now this time, governor will have to give the assent on his or her own. Cannot go and knock the doors of the president that now it's you who should give me the authority or give the bill the authority to be converted into an act. No, not permitted, not allowed. Right? So this is what the general condition is. As we can see here, Supreme Court has penned down an exception. What is the exception? The only exception is when the bill presented in the second round is different from the first version. Okay, so now the condition. The second case. Okay, simply the second case. The bill is sent to the governor, and now the governor sees that the bill that came to me for the first time was having different provisions, and now the bill which is coming to me for the second time, it's totally based on some new provisions. The whole theme, the whole genesis, okay, the whole face of the bill has been changed. In that case only, the president can use the transferable veto. Not in the very first case. That is, if the reconsideration was done or maybe not even done, but the bill was presented to the governor for the second time. Even in that case, not allowed. Okay, but yes, if in the second condition, okay, the governor sees that the reconsideration is not yet done, but some extra things have been added to the bill, or let's say some new provisions have been added to the bill and the previous one are totally gone. The previous ones are totally deleted, omitted or vanished or whatsoever. Right? Now the bill's genesis has changed. The bill's theme has changed. In that case only, the governor can use the transferable veto. Okay, so I hope this should have given you the clear insights on the Supreme Court's judgment. Right? So now moving ahead with the facts. What Supreme Court has added, that is the time limits that was badly needed in order to provide some safety to the quasi-federal structure of our country, right? So what is the time limit? So in a significant move, the court fixed the time limits of 1 to 3 months variously for governors to take call on the bills. Till yesterday, there was nothing known as time limits. But from today onwards, whenever the bills are presented to the governor, there will be time limits. So what are the time limits? As we can see here. So the first thing, that is 1 month. Okay, 1 month as in 1 month to withhold assent on the aid and advice of the state cabinet. Okay, simply 1 month. But this 1 month time period should be justified by the aid or advice of the state cabinet, not council, cabinet ministers. Okay. So 1 month to withhold the assent on the advice of what? On the advice of state cabinet. Second, if he withholds the assent contrary to the cabinet's advice, maybe cabinet has said that no, you can pass the bill, but let's say still governor has hold the bill. That is contrary to the cabinet's advice. Then governor has a maximum of 3 months to return the bill with a message specifying his reasons. Okay. So the first condition is 1 month. That is itself, the state cabinet itself has suggested that wait. Okay. Just wait 1 month to withhold the assent on the aid and advice of the cabinet. Okay. Second one is maximum time up to 3 months, that is 90 days. And what is this? That is when cabinet has said, okay, dear governor, Mr. Governor, aap sign kar sakte hain, you can sign, okay, no problem in that. But still, governor thinks that there are some provisions that should be upgraded or changed or whatsoever, should be amended whatsoever, right? In that case, governor has time, that is 30 days, 90 days, that is basically 3 months. Third condition, the governor has 3 months to reserve a bill for the president's consideration against the advice of the state cabinet. Now, the third condition is, let's say the governor thinks that though the state government or the state cabinet has provided me the advice that okay, I must go ahead and provide the assent to the concerned bill, but in my opinion, I think it should be the president who would be taking charge, of whether giving the assent or not. So in that case also, governor has got how much time? 3 months, basically 90 days in both the cases when going against the advice of the state cabinet. Okay, and we have got the fourth option as well, the fourth scenario as well. What is that? The governor must grant assent to a bill repassed by the state legislature under Article 200 within a maximum of 1 month. Let's say governor has used his or her this suspensive veto. Okay, and now the bill is represented to the governor with or without considerations whatsoever. Then in that case, the governor will have to give the assent within 1 month only. Okay, so let's understand the whole scenario in detail. Okay, so the first thing is 1 month. Okay, where the 30 days time has been given. So 30 days time, it is given in two distinct scenarios. Okay, what is that scenario? First, when the state cabinet has said that you can give the assent, no problem. Okay, so this is what the 30-day scenario, as you can see. Okay, 1 month to withhold assent on the state and advice on the aid and advice of the state cabinet. Okay, so when the state cabinet itself has approved 30 days of the time, right? And second 30 days comes when must grant assent to bill repassed by the state legislature. Okay, when it is repassed, okay, whatsoever, with or without the consideration. So these are the two scenarios where the governor is given with 30 days of the time. Okay, that is one, when the state cabinet itself has said, okay, you can give the assent. So in that case also you can have 30 days. Okay, other, that is when the bill has been sent back to the legislature for some considerations and the bill now is considered by the state legislature, okay, or even not considered by the state legislature, those suggestions are taken or not taken whatsoever, but still the bill is now sent back to the governor. In that case also 30 days, maximum 30 days. Okay, now the concept of 90 days, that is 3 months. So here, if he withholds assent contrary to the cabinet's advice, he has maximum of 3 months to return the bill with a message specifying the reasons and 3 months to reserve the bill for the presidential assent. Okay, so the concept of 90 days would come. Okay, 90 days. Where firstly to use suspensive veto. Okay, firstly to use the suspensive veto, that is to send the bill back to whom? Back to state legislature. Okay, and 90 days or 3 months again. Okay, to send or transfer the bill for the assent of President. Okay, simply this is what the whole logic is. 30 days in two cases, two scenarios, and 90 days in two scenarios as well, right? So this is what the time limit that is specified by the Honorable Supreme Court of India for the governors to provide the assent, withhold the assent, or transfer the assent with regard to the state legislative assembly bills, right? So Supreme Court has come to the rescue. Okay, and yes, it's the victory of Tamil Nadu government. It's the victory of M.K. Stalin's government, right? A historic event, as Tamil Nadu has already mentioned. That is, it is something that comes with the virtue of the Raj Mannar Committee. Raj Mannar Committee, if you are watching the Hindu Analysis session daily, so today only, we have discussed about the Raj Mannar Committee, established in 1969 by the Tamil Nadu government itself, which submitted its report in the year 1971, which provided more autonomy. The recommendations of the committee was providing of more autonomy to the states, right? So here we go with the MCQs. Article 200 provides that the governor may reserve a bill for the consideration of the president, or which of the following bills must be reserved. Okay, so yes, governor has a discretion to send the bill for the assent of the president. Okay, but there are certain types of bills for which governor is absolutely entitled to transfer the bill for the presidential assent. Okay, so which one of them is one such bill that mandatorily demands presidential assent? Okay, so option A bill that seeks to restrict interstate trade. Option B, money bill increasing the salary of the MLAs. Option C, bill that merely deals with the name of the government department. Option D, a bill promoting the official language of the state. So what do you think is the correct answer? Yes, so the correct answer is option B. Option A. That is, when a bill that seeks to restrict the interstate trade under Article 300 clause 4B. Okay, so 304 clause B actually. Okay, so Article 255. In such instances, right, whenever the bill is related to these such articles, okay, in that case it is the duty of the governor, the prime responsibility of the governor to send the bill for the assent of the president. Okay. Next, which of the following judgment of the Supreme Court are relevant in understanding the limits and the role of the governor in a state legislative affairs? Okay, so which are the cases that dealt with the role of the governor when it comes to the state legislative assembly affairs or their actions or the business? Okay, so is it the Shamsher Singh versus State of Punjab 1974, or S.R. Bomai versus Union of India 1994, or is it the Nabam Rabia versus Deputy Speaker 2016? So which one? 1 and 2, 2 and 3, 1 and 3, or 1, 2 and 3? So basically speaking, all of these cases dealt with the position of governor inside the state. Okay, all of these cases, from Shamsher Singh case to Nabam Rabia case to S.R. Bomai case, all of these cases, they dealt with the position of governor inside the state and its affairs. Okay, so Shamsher Singh case 1974, it asserted that the governor is the constitutional head and must act on the aid and advice of the Council of Ministers under Article 163, just like President performs under Article 74. Okay, next, S.R. Bomai 1994 dealt with the federalism and misuse of Article 356, but also emphasized the role of constitutional functionaries inside or upholding the democratic values, specifically governor. Okay, and third one, that is the Nabam Rabia versus the Deputy Speaker 2016 case, reiterated that the governor cannot act in a discretion in matters where he is required to act on the Council of Ministers' advice, especially, okay, in summoning or dissolving the legislature. Okay, so just like President has to act on the aid and advice of the Union Council of Ministers under Article 74, the governor has to perform the same, that is, working on the aid and advice of the State Council of Ministers under Article 163, right? So this is what Supreme Court has stated in the Nabam Rabia versus Deputy Speaker case of 2016. Next, in 2024, the Tamil Nadu Legislative Assembly passed a resolution seeking to recall as in remove Governor R.N. Ravi. So, in this context, which of the following is correct regarding the appointment and removal of the governor or the governors in the states that is of India? Okay. So, option A, governors can be removed by the president only on the advice of the state legislature. Option B, governors can be impeached by the parliament in the manner similar to the president. Option C, governors hold office during the pleasure of the president and can be removed, okay, without giving any reasons by the president only. And option D, governors can only be removed by the Supreme Court through a writ petition. So A, B, C, and D. We have got four options. Okay, so the correct answer is option C. Governors, they hold office during the pleasure of the president, and the president can remove them anytime. Obviously, president has to take in consideration the advice of the central, that is the Union Council of Ministers. Once again, Article 74. Right? So governors cannot be removed by the Supreme Court, neither by the state legislature, neither the state legislature can provide any recommendations to the governor or to the president. The president acts on his or her own. Okay? Obviously, not through the discretion, but through advice rendered to him or her by the Union Council of Ministers, that is under Article 74 basically. Okay? So, the governor, they take office on the pleasure of what? On the pleasure of President of India only. Okay, and can be removed, appointed or transferred by the President of India only. No second authority from the state legislature to state government to to Supreme Court or High Courts in India will be in action here. Okay, so we have last MCQ for the day. Here we go. In the 2024 ruling, the Supreme Court invoked the principle of constitutional morality. What does this principle imply in the context of governor's assent? Okay, we have discussed ample amount of time in our previous sessions, okay, in the Hindu analysis as well as other interesting topics of the day, okay, about the constitutional morality. And here it is the question with regard to the same. Option A, the governor must act solely based on the personal conscience. Option B, the governor must uphold the dignity of the constitution and act in a good faith. Option C, the governor must follow the will of the president in all the matters. And option D, the governor may delay bills if they are politically controversial. So the fact is, with regard to the constitutional morality, that is acting morally, simply speaking, acting in a good faith. And the good faith word is here, that is the governor must uphold the dignity of the constitution and act in a good faith. If it is politically controversial, okay, then you will have to provide the reconsideration to the state legislature or send the bill for the presidential assent. Okay, the governor must act solely based on the personal conscience. No, that's dictatorship. Okay, option B is also something. Okay, option C, that is the governor must follow the will of the president in all the matters. No, it will disturb the concept of federalism. Okay, so we talk about constitutional morality, so acting in good faith, okay, upholding the dignity of the constitution, okay, that is what? Option B, right? So the governor must act in a good faith, upholding the constitutional morality. Okay, so these are all what the topics we need to discuss, okay, with regard to today's news on R.N. Ravi's actions on sending or transferring the bills, 10 bills to the presidential assent when it was returned back to him by the state legislature. Okay, so that was constitutionally not correct. You can transfer the bill, but at first instance only, not in the second instance, right? So we had a phrase here today, okay, that is non est factum. Okay, the Supreme Court, Justice Pardiwala, while delivering the judgment, mentioned this term non est factum. What is this non est factum? That is basically a plea that had a written agreement, okay, which asks the plea or the agreement to be declared as null and void. Okay, so a plea that a written agreement is invalid. Okay, why? Because the defendant, that is the one who had pleaded, was mistaken about its character when signing it. So let's say you are signing an agreement with another party, okay, and when you have signed the agreement, then you realized that, oh, fish, it's a mistake. I misinterpreted the protocols or the provisions of the agreement. So in that case, you can use the term what? Non est factum. Basically, you can plead in front of the court that while reading the provisions of the agreement, I had a mistake, I misinterpreted some of the provisions, and please just nullify this bill, nullify this agreement. Okay, so that is what is termed as non est factum. Okay, guys, so that's it from my side today in this interesting session. And yes, please do subscribe to our StudyIQ IS English channel. It's made just with one purpose, that is to serve you at the best quality and quantity of the content that is required for you to crack the UPSC CSE, that is Civil Services Examination. Okay, everyone, and in ways you need to connect with me through my social media handles. So on Instagram, you can search, the username is there, Praveen Mishra _2107, or else on Telegram, you can connect with me in the term study_with_Praveen. Right, so just go on the search bar, okay, wherever you are comfortable, Instagram or Telegram, just type down the names and you'll connect with me. Okay, guys, thank you so much for watching. Do hit the like button in case you like the video, and apart from that, what's your feedback over the issue? I would really like to know in the comment section. Okay, everyone, see you soon in the next session. Bye bye, good day, take care. Jai Hind, Jai Bharat.